Hello, everyone, and welcome to the APS Building Safety Act sessions accompanying YouTube series of Q&As. Today, we are joined by Andrew Leslie of APS and Mark Snelling of Safety Bar, future APS president. As you may well know, if you've attended one of our Building Safety Act sessions, we tend to run out of time at the end. The Building Safety Act is an incredible beast, very, very full of information, and we don't always get to the questions, and some questions need a little bit more time to answer. So that's what we're going to do today. We're going to do a series of videos, and we are going to answer as many questions as possible. And if you have any other queries or comments, please get them to me, and hopefully we'll be able to ask them on the next questions. Hello, Andrew, and hello, Mark. I'm going to start with the questions today.
Good afternoon.
So, question one. Morning. Whatever time people are watching this, I hope they're well.
That's true. Good day.
The joys of YouTube. Good noon. So, question one, Andrew and Mark. With regards to the client's competence and their principal appointed person, will the building safety regulator approve their safety case for a HRB and the construction control plan if the principal appointed person cannot meet the required competence standard?
There was a lot of lobbying going on during the early stages of the Building Safety Act relating to competence of duty holders in occupation. And the point that was being made that a lot of higher risk buildings are managed by residence management companies, which are companies set up by residents, leaseholders, to manage their own building. They are the directors are lay directors. In most cases, they have to come from residents. There is a provision not yet put in place for building safety directors to be appointed by these companies, but there was a point made that principal accountable point. You cannot. A person is a principal accountable person. And you can't mandate that they're competent because it relates to their ownership of the building. So the two things are not compatible. So there is no requirement for a principal accountable person to be competent. However, there is a requirement in the principles of managing building safety risk that they engage anybody they engage to manage building safety on their behalf. Has the skills, knowledge, experience, and behaviours or organisational capability. So it's within there. And some of you may remember that originally it was proposed that they must appoint a building safety manager. And that was also to try to get around this problem that principal accountable persons couldn't be made to be competent. So they had to appoint somebody who was going to be competent, was going to be certified. That all disappeared, which created this void, which is now being filled by the general competence requirement. But I think there is a general belief that new competence requirement should resolve the problem.
Thank you so much, Mark. Question two to both of you. Why not go for one PD embracing everything?
Well, that was the original intention of HSE, and it remains an objective. I think the reality is that there's probably insufficient supply of competent individuals and organizations, and that inevitably there will be projects where there would have to be two appointments.
It's interesting. You Andrew, you sent me something the other day on the HSE website, which I've asked a question of them which sort of really pushes this message that's suggesting they really want one. And I think they always have want one. I had a conversation with somebody yesterday from a past principal inspector who reinforced this. She was saying that this person had reinforced that message that they really want the lead designer to take on both roles. But the legislation is written so that there is no legal mandate for that to happen. And I think the need for competency and professional indemnity insurance, I suppose, overwrites any mandate in that area. So we will still continue to get principal designers under building regulations and principal designers under CDM regulations being separate for a number of reasons, but it's still going to happen, and there is nothing in the law that says it must be the same organization.
Thank you both. Question 3: will there be a need to have a CDM specialist involved with projects to ensure that all duties are upheld?
I would say yes. Nothing has changed really in that respect.
The competency requirements under CDM regulations still exist. And if you take on the role of principal designer under the CDM regulations, you must be competent if that's held within an organization who is also undertaking the building regulations. They will need to be competent or have somebody within that organization that is competent. So I totally agree with Andrew. Yes, and yes again.
Lovely. I love a sharp, succinct answer. Question 4: should PDs providing CDM service only use the time? Should PDs providing CDM service only use the title CDM Principal Designer to make it clear that it is the service provided and all appointment documentation amended to make reference to CDM PD?
That makes a lot of sense, and I think it's quite important that if you're employed to do something, the job that you're doing is clearly specified. And so I think the question points to a situation where a client may appoint you as principal designer, and all sorts of confusion could arise if that is misconstrued as principal designer, building regulations, and CDM. So yes, be specific with your appointment documentation.
Yeah, that makes sense. Question 5: will the APS be providing sample appointment documentation for BSA PD and an update of the CDM PD?
The answer to that is yes. We've been speaking with our legal team for some time about the appointment documentation. Now that all the legislation has been published, that work will be underway. And the CDM documentation is being reviewed. The CDM appointment documentation is being reviewed, and we will also have a look at the appointment documents for the principal designer building regulations. That's still to be decided whether we will do that at APS or leave it to somebody else.
Thank you ever so much. Question 6: would it be possible to issue a high-level summary of how the new regulation affect non-HRBs, as I'm trying to understand how this legislation affects my current and further projects? I understand there is more legislation for high-rise buildings, but I am struggling to split out this element, as all my projects do not fall under this category.
I think it's been quite interesting because the new regulations modify the building regulations, so it's really clear now that the changes we're talking about, the changes to duty holders and competence, relate to the building regulations. They are part of the building regulations, and they are obviously relevant to all work to which the building regulations apply. So that is entirely clear. And I know there's been a lot of conversation in the lead up to this about how the Building Safety Act and the secondary legislation relates to high-risk buildings, but this secondary legislation changes the building regulations, and they form part of the building regulations, so they clearly apply to all work to which the building regulations apply. The change is also disapplied. So building regulations are made up of two bits, really, or two fundamental bits. One is the functional requirements, and one is the procedural requirements. And the secondary piece of legislation that applies to high-risk buildings relates to the procedural requirements that introduces the gateways. Although I noticed that the terminology in the new legislation seems to be moving away from the gateways as a title, and it's whilst the golden thread is kept as a title, but the gateways seem to have moved. So the building regulations applies to, from a standards point of view, applies to all work to which the regulations apply. from a procedural point of view, that the procedures relating to high risk buildings are separately dealt with and disapplied within the building regulations. So it's really quite simple. We've got two sets of regulations. One applies to high risk buildings procedures. The other building regulations applies to all work and sets the standards. So I hope that explains it.
Oh, clear as day. Clear as day. Question 7. Will the new course that we'll be running also available to corporate APS members such as our architects?
It's available to everybody. Yes, it's proving to be quite popular at the minute. So encouraging everybody to sign up. It's a full day's course. It covers all aspects of the construction element, the building work element of the building regulations, and then also how that links into the occupational phase, because obviously there are some projects that are being carried out that won't be under the new regime, but will be handing over buildings that will be in the new regime. And of course, there's a need to prepare to be able to hand over the right information to that. So it's going to cover all of that. It's available to anybody who wants to sign up and pay the money.
And just as a further shameless plug, if you go to the website, the details are on there on how to sign up for it. You do need to email Anthony Taylor. His email address is there for you. Question 8. On the issue of proof of competency from a non-PD and general designer perspective, and based on experiences, how will new practices prove experience? And or if wishing to venture into sectors, how will that be affected if no particular past experience in that sector, i.e., say usually do residential but wish to expand in healthcare, commercial and education?
What will be required, I believe, in fact, it's clear that if a practice wishes to move into an area, they will need to engage somebody who has experience in that area to either oversee what they do or deliver what they do, to give them experience. So it is that find somebody, if you want to move into that area, find some area who's worked in that area, who can lead the practice into that area, has that overarching skill. It's a supervision piece. If you look at the skills, knowledge, experience and behaviors, it comes back to that you either have the skills, knowledge, experience and behaviors, or are supervised by somebody who has the skills, knowledge, experience and behaviors. And it really comes within that category of the definition. Find somebody who's done it to either oversee what you do or to deliver what you do.
Yeah, you can think of it in these terms. If you're wanting to move to a different building type, use the same sort of thinking as you would if you were not an acoustic specialist. You need to get somebody on board that is an acoustic specialist. Or another example, if you're an architect or a technologist, you won't necessarily do structural work, so you get a structural specialist in. So if you're moving from housing to nuclear power stations, you need somebody on board that knows about nuclear power stations.
Thank you both. Question 9. Can you be more specific about what we will need to do to comply with the Act as PD for BSA and CDM?
Under CDM, there's really no changes to the requirements for CDM, except that you will be a duty holder under the building regulations, in the sense that you're a designer. So therefore, as any advice you give relates to the building regulations, you need to ensure that whatever advice you give as a principal designer, advice, guidance, ensuring complies with the requirements of the building regulations. So you do need to, if you're not familiar with the building regulations what they require, there is clearly a need to upskill in that area. So we were looking at it's covered in, say, shameless plug, but it's covered in the course about the sorts of things that would look like. It would probably be, it's primarily Part K is the biggest. Part K of the building regulations provides most crossover detail, but you've also got Part A, which is structures, and Part B, which is fire safety. Part K is falls and related issues. And then, of course, you've got to understand the procedural requirements of the building regulations that relate to whatever work you're doing, be that high-risk buildings or other buildings, so that you can ensure that you understand it with enough detail to be able to fit in with the regime and make sure you comply and make sure you understand your duties relating to competence and your duties under the building regulations to cooperate with other duties. So that's the PD under CDM. So there are some changes, and the role of PD under building regulations. It's really there will be people, I've said many times before, there will be people under already with contractual responsibilities for coordinating building regulations compliance, lead designer, lead. I was interesting to note on the latest report that came out on the CDM regulations of how many projects relate to civil engineering. So of course you get lead engineer could be leading on, although I have to say building regulations has limited effect on civil projects. But it's whoever that will be doing that already, and they need to take on, so they've got the contractual responsibilities now. This just introduces criminal liabilities. And then of course there'll be additional competencies relating to understanding the new duties, the changes to the building regulations, and if they're working on higher risk building projects, how the new procedural requirements relate. But in a way, there's a lot of change, but no change. People are doing this already, or should be doing this already. Yeah. It's just understanding the new process that's described in the building regulations or the procedural requirements that relate to high-risk buildings.
Thank you. And the final question, I'm going to throw this one at Andrew, because I like to hear Andrew talk. The new legislation, question 10, the new legislation, although most important, may reduce the number of competent organisations due to the complexities and requirements, which might have complications for development schemes in access to such provision. What is the panel's view on maintaining sufficient provision in the short to medium term?
Well, I think industry will need to step up. Most professionally qualified lead designers are already doing it in terms of the PD building regulation role. And as Marcus said, the change that these lead designers face is the liability change, the additional criminal liability. This is all going to have an effect on professional indemnity insurance. And therefore, some organizations are going to risk assess whether or not they're going to get involved in the project. And some organizations who are already doing it may find themselves having to refuse the PD building regulations appointment. It's now the law, and unless the industry wants to see a substantial and significant slowdown in building, which will have all sorts of economic ramifications, then organizations and individuals are just going to have to fill the available jobs presented by the new legislation, and of course the existing CDM regulations.
I think interestingly that the PII, the professional indemnity insurance piece, I don't know what you think, Andrew, but the adding of criminal liability can't really be insured against. Okay, you can be insured to cover your court costs. So that it shouldn't affect PII from that perspective. I think what changes, and then in a way it'll change whatever role you do, is that certainly if they introduce they commence section 38 of the building regulations, which introduces and extends civil liability in relationship to failures in building regulation compliance. And there are some other, the Defective Premises Act changes will affect that. But that sort of happened already, whether or not you take on the role of PD. What do you think, Andrew?
Yeah, I mean, I think your PI insurance will not cover you for any aspect of negligence. And I think is my understanding. I haven't had my own PI insurance for a couple of years. But if you're prosecuted under either of these sets of regulations, then you're being prosecuted for a failure. And depending on the nature of that prosecution, you won't be insured anyway for anything, any of the costs, including court costs, is my understanding. So the reason I mentioned PI is that my belief is, from what I've heard, most of it is rumor and stuff, is that PI underwriters are pretty nervous about all of this, in the same way as they're nervous about building in basements and floodplains and so on, and cladding materials. And it's likely that premiums are going to go up rather than go sideways or down. And generally speaking, I think that, going back to the original question, there is a body of work to be done on projects, and the new building regulations introduce new duty holders, and the new duty holders that are being introduced are quite clearly aimed at lead designers who will already have PI to do certain types of work. And it's anybody's guess how that is going to be, how the PI situation will impact. But going back to my original point, the lead designers are doing it already in terms of the building regulations. The bit they're not doing, or a large proportion of lead designers are not doing, is CDM. And that is the historical position. So, although it's a bit of a jumbled up answer there, I hope that that covers the ground.
Brilliant. Thank you ever so much, Andrew, and thank you ever so much, Mark. That is the end of our Q&A session for today. There will be more to come. Thank you ever so much. Thank you, Andrew. Thank you, Mark.